creativity is a social experience. You're not creative alone.
Despite its struggles, ESG can overcome the criticism and help make companies more accountable towards all stakeholders.
Today we're going to talk about things like trust and teams,
Bitcoin, blockchain, cryptocurrencies.
Hello and welcome to this latest Reskill Masterclass from the HEC Paris campus. I'm the school's head of research communication, Daniel Brown. Today it's our great pleasure to welcome Pablo Baquero, who's the assistant professor in the law and tax departments at HEC Paris. Pablo, it's a real pleasure to welcome you to this masterclass.
My pleasure.
Pablo's going to discuss the impact of the EU AI Act on companies operating both within and beyond Europe. And after your 20-minute presentation, Pablo, you're going to answer the numerous questions that our viewers have been sending on this very topical subject. Well, Pablo, the floor is yours.
Thank you very much, Daniel. It's a pleasure to be here to discuss with you the impact of the European Union Artificial Intelligence Act on businesses. There is much concern nowadays in the business world among market actors about the potential chilling effects that regulation might have on innovation and particularly on technology adoption by firms. So we have made a poll prior to this session and we have asked you the following question. Does the European AI Act risks slowing Europe down compared to the US and China in development of AI technologies? And the majority of you said yes, the AI Act is too burdensome and slow. 36% said that actually this is a false choice, both innovation and regulation can align. And 17% said that no, even if the regulation slows down, we have to give prevalence to ethical values in the European Union and to enforce those regulations. So as you can see, this is very much a divided opinion. So there's conflicting views about this topic. And this is not surprising at all, because in the end, the Artificial Intelligence Act of the European Union is the first comprehensive framework specific on artificial intelligence created by a major regulator. And the European Union AI Act has significant impacts on businesses, some that we are going to be discussing throughout this session. But it's not the only piece of legislation in the EU governing artificial intelligence. There are others, such as the Digital Services Act, the Digital Markets Act, the General Data Protection Regulation, among other regulations and directives. But often the EU AI Act is considered to be the centerpiece of the regulation of AI in Europe, and in fact, an instrument that has been very influential also in other countries, inspiring them on how to draft and design their own projects to regulate artificial intelligence. So what is the status of the EU AI Act? Has it already entered into force? So in this timeline that we are projecting to you, you can see that the AI Act has entered into force in August 2024. Some of its rules have already become applicable, particularly rules on the prohibited AI systems, systems that are banned from being implemented in the European Union. But many other rules are still to become applicable in the future. In August 2025, we are going to have some rules on general purpose artificial intelligence becoming applicable, and then in 24 months, in 2026, August, we're going to have the rules on high-risk AI systems becoming applicable. And finally, in 2027, still some additional rules still on high-risk AI systems. So it's a very complex process of implementing this act along a complex timeline. But since this is a very timely question, because the EU AI Act is just entering into force gradually, this question about regulation potentially discouraging innovation has become very much pressing. And in the European Union, this discussion has been combined with calls for more competitiveness of the European bloc, particularly because there is a sense that we are potentially falling behind the United States and China in relation to the development of technology. But even before we can deepen this discussion more, we have to understand what is the regulatory approach of the EU AI Act and what are some of the problems, what are some of the issues that in the first place the Act was seeking to address. And perhaps the best way to look into the specific problems that the Act seeks to address is by looking at some of the major cases involving harms, involving problems caused by AI technologies that have been reported in the news, that have been discussed in the academic literature, and that very likely were in the mind of the European regulators when they drafted the project of the EU AI Act. So let me tell you about 3 different cases. The first case involves Clearview, a company that developed a software to be sold to different private security firms and police departments around the world. So this software would be used to scrape images publicly available online, billions of images containing the facial features of individuals. And they would be compared with the images of suspects, of persons of interest, trying to find matches. As you might imagine, this technology has been very controversial. It has even been banned before the EU AI Act in countries such as France or the UK. And a major concern was particularly the lack of data protection. There was a fear that by collecting those images without the authorization of the individuals that had their facial features collected and processed, a privacy violation, a data protection violation would be occurring. So this is one of the major issues, one of the major problems that AI technologies might cause, the breach of privacy, breach of data protection. The second case I want to tell you about involves an algorithm that was implemented by the UK government during the pandemic to predict what would be the performance of students and to allocate them to different universities to determine from which universities they would be receiving offers to enroll. Now, normally, this decision, this analysis would be made based on the A-level tests that high school pupils would take. But during the pandemic, of course, it was impossible for students to take this test due to the social distancing measures that were in place. So the UK government decided to implement this algorithm to predict the results. When the results came out, however, there was a lot of controversy. And it was found that their results were biased against students from public schools and favored students coming from affluent areas that were going to private schools. So that's another potential major problem that can be caused by AI technologies, discrimination or bias against certain groups of individuals. The third case, and the last one that I'm going to be discussing in this masterclass, involves the use of the software Horizon by the UK Postal Office. So this software was being used to monitor the accounting of the different local branches of the post office that were being managed by third parties. And they were trying to look for potential inaccuracies, for potential mistakes, or even for fraud. And based on the results, many local branches and particular employees were wrongly accused, subject to judicial litigation and other forms of punishment. The results on the employees and local administrators was terrible. Some people went to prison, others have fallen into depression. There were even cases of suicide, all because of the wrong functioning of this software. So the lack of accuracy, the lack of reliability is one of the major problems that can be caused also by AI technologies. So all these cases, they illustrate some of the major issues that very likely were in the head of the European legislator when it decided to create the EU AI Act, through mandatory rules, through binding rules. So let us focus now on the EU AI Act. So this instrument has the design, or was structured as an instrument of product safety, as a product safety regulation. What does that mean? It means that it imposes requirements for products and services, in this particular case, implementing AI systems, requirements that have to be met for those particular products and services to be launched into the market. And the regulation further establishes the requirement for those products and services to be monitored after they have been launched into the market to assure that over their lifetime they remain lawful and compliant with the regulation. The AI Act, as its title in itself says, is an EU regulation, and that means that it seeks to harmonize the rules involving artificial intelligence across the different EU member states, and to facilitate free commerce and innovation throughout the different members of the European Union. But besides only promoting free trade and facilitating innovation, the EU AI Act is also about protecting the fundamental rights of EU citizens against potential breaches that could occur through the use of technology. So this need to balance the protection of fundamental rights and the promotion of innovation and free trade is one of the major issues, cornerstones of the AI Act. So to whom does the AI Act apply? To different actors in the AI supply chain. Primarily to the developers or providers of those AI technologies, but also to the companies that incorporate those technologies in their products and services and launch them into the market, the so-called deployers. There are also rules relevant to distributors, to importers, and to exporters. And very importantly, the EU AI Act applies not only to European companies or to companies headquartered in Europe. In some cases, it also can apply to foreign companies. For instance, developers of technology that are located abroad, but that then have this technology implemented, launched into the European market, they also have to fulfill, or they also have to comply with the rules of the AI Act. But if we are discussing an instrument that regulates artificial intelligence, we have to understand what is the definition that this instrument adopts regarding artificial intelligence. And as we are going to see in a second, there's often an argument being made that the concept of artificial intelligence adopted by the Act is over-inclusive, it's too broad, and sometimes covers very simple types of software, not only the more advanced types of machine learning techniques that often we have in mind when we discuss artificial intelligence. So let us look what is the definition of AI that is in Article 3.1 of the AI Act. The definition is as follows: a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So as you can see, this is a very broad definition that very likely can include and that can over-regulate. For instance, it can over-regulate very simple types of software that are not in the frontier of technology. Doesn't that mean that the EU AI Act is overreaching by regulating even those very simple types of technologies? Well, sometimes a very simple type of software can also create significant dangers and produce risks that somehow should be managed. In any case, the approach adopted by the EU AI Act to a certain extent solves this problem. The AI Act adopts a so-called risk regulation approach. Different types of AI systems are subject to different types of rules according to the risk that they pose to individuals or to society. Some AI systems are subject to very stringent rules, whereas others might be subject to no rule whatsoever because they are considered not to present any risk. Under the EU AI Act, as you can see in this projection, there are 4 levels of risk that subject different types of systems to different rules. The first level refers to the prohibited AI systems, those that present an unacceptable risk and that are simply banned from the European market. So examples of those banned systems include, for instance, algorithms that predict the likelihood that someone will commit a crime in the future, that they will reoffend, or also the use of facial recognition systems in real time to monitor publicly accessible spaces. These will be banned except in very special circumstances that are laid out in the Act. The second level of risk refers to those high-risk AI systems. Those can be launched in the market, but before doing so, they must fulfill a number of requirements that we are going to discuss in a minute. The AI Act is to a great extent targeting those high-risk AI systems. Perhaps the majority of the rules refer to the requirement that those high-risk AI systems must fulfill to be able to be entering into the European market. Some examples of high-risk AI systems involve algorithms used in the area of educational and vocational training, for instance, to determine whether someone can have access to a particular university, algorithms that determine whether someone will receive a public benefit from the government, and also algorithms that are used for hiring purposes to determine whether someone will be called for an interview. We then also have a third level of risk, which refers to those AI systems that present a limited risk. In relation to those, we have essentially a transparency requirement. That means providing information for the users interacting with those AI systems, that they are dealing not with a human being behind the screen, but with an AI system with a machine. And finally, then we have AI systems that fall into the fourth level of risk, or minimal risk, and that are simply not covered, have no rules under the AI Act covering them. There might be special codes of conduct created by industry actors that might serve to guide the development of those technologies, but otherwise there will be no mandatory rules for those under the EU AI Act. But now let us take a minute to discuss those high-risk AI systems, which I have said are the real focus of the AI Act, or that at least have more provisions addressing them. Those high-risk AI systems must fulfill a number of requirements before they are launched into the market. Let me give you an overview of some of the main requirements they must fulfill. First, they have to fulfill a number of data governance rules or practices. For instance, we must make sure that those algorithms are trained with data that is collected in a lawful way and that does not use any type of personal sensitive data that is not available to be used according to the General Data Protection Regulation. Second, these types of high-risk AI systems, they must comply with a requirement of non-discrimination. They cannot discriminate, they cannot be biased against certain groups or certain types of individuals. For instance, we cannot discriminate based on sex, on religion, on ethnicity, on nationality, on sexual orientation, on political views. That is banned. There is a requirement that those algorithms should not discriminate based on that. A third requirement that those high-risk AI systems must fulfill is transparency and explainability. We must have a general understanding about how those AI systems work and understand how recommendations, predictions, outputs are being generated. Then we also have a requirement that those systems must be designed in such a way that a human being will be able to oversee and potentially make improvements or correct the way the system is working if there is any inaccuracy or improper functioning of that particular algorithm. And finally, those algorithms also must be reliable, they must be cyber secure, they must be accurate. They must not produce mistakes such as the ones that we have seen in the case of the Horizon software used by the UK Postal Service. But many of those requirements that I have mentioned to you, they are very broad, very generic, very abstract. How to implement in practice and what kinds of technical guidelines should we be following to implement general ideas such as transparency, non-discrimination, accuracy. So there are different technical standards that are being developed by standardization bodies all over the world and in Europe in particular to try to convey, to specify in detail what those very general concepts mean in practice and how to implement them from a technical perspective. In the European Union, for the purposes of creating standards for AI governance, there are 3 standardization bodies that are recognized. They are CEN, CENELEC, and HEC. And there is a lot of discussion nowadays all over the world about the role that these institutions have in the production of such standards. Because many say that since those entities are mostly formed by industry actors, there is very little transparency and very little participation of the civil society in the way those standards are being produced. So there are many questions nowadays about whether the way those technical standards are being produced create real legitimacy for them and for the general functioning of the AI Act that will rely to a great extent on these technical standards. One final point to make is penalties. There are different types of penalties that are established under the EU AI Act for companies that potentially violate any of the obligations established therein. But the most important types of penalties are the fines that are established in the Act. And the amount of the fines is going to depend on the type of obligation that has been violated. So that's something that we would have to look more closely into the AI Act to be able to analyze. In conclusion, for businesses nowadays, particularly for those in the technology area or wishing to adapt artificial intelligence, it is crucial to understand the level of risk that the artificial intelligence technologies they are implementing have according to the EU AI Act. It's crucial to understand the requirements that under the regulation they have to comply with to be lawful and what potential penalties they might incur if they violate those. In any case, it is important to know that this is still a moving field. As I have said, there's many technical standards still being produced that will determine in practice how the EU AI Act will function. So those were the observations I wanted to make. I thank you for your attention and I remain available to answer any questions you may have.
Pablo, thank you very much for a very rich presentation of this EU AI Act. We've got a lot of questions that came in the past 2 days since we invited our viewers to talk about this and address their observations. And I want to first bring up a question that Marie sent in, and she was wondering about generative AI systems. And Marie, you were saying that you weren't sure if these were covered by the EU AI Act. So, Pablo.
So thank you very much, Marie. This is actually an extremely relevant question. So first of all, let's have a look behind. When the EU AI Act was first drafted when its first version came out in 2021, the European Union Commission made a project. There were no rules specific on generative AI. And at that point, you might remember that ChatGPT version 3.5 had not been launched yet. And it was with the version 3.5 that we reached really a dissemination of these models across society. There were in less than 2 months, or in about 2 months, 100 million users that adopted this technology. So when that happened in 2022, even though the first version of the AI Act had already come out without rules on generative AI, the regulator said, well, we are realizing this is a very important phenomenon and perhaps we should have some specific rules to govern generative AI. So in the subsequent versions, and finally in the final version of the AI Act, there are, yes, specific rules on generative AI, but they are referred under the AI Act as general purpose AI systems. And what were some of the concerns that the regulator had? Well, the problem with those types of general purpose AI systems is that, as the name itself says, they can be used for basically anything. You can ask ChatGPT to produce a poem. You can ask them to give guidance on gun safety. You can ask them to produce a legal brief, even though it might be more perfect or imperfect according to the task you're asking. They can be used for a generality of purposes. So it's very difficult to really evaluate the risk that they might be creating for each particular circumstance. So in practice, what kinds of rules were created for generative AI systems or for general purpose AI systems? So first of all, of course, they are subject to the general rules on risk-based regulation that I have already mentioned. So for different fields, there are different requirements. If they are considered to be high-risk AI systems, they will be subject to those requirements. But there are additional specific rules that apply to them. And once again, the regulator makes a distinction between those ordinary types of general purpose AI systems and those that present a systemic risk. Those that present a systemic risk are considered so based on different criteria. Computing power is the most important of them, but others can be considered: how disseminated they are in the market, how many users they have. And there are different rules that apply to them. So all types of generative purpose or general purpose AI systems will be subject to the following rules. They must comply with copyright rules. We must make sure that they are not being fed on data illegally in a way that does not comply with copyright. There must be a summary produced explaining what are the sources from which we are using or basing the data that we are feeding to this system, and providing general transparency on how the system works. Now, if we have a general purpose AI system that presents a systemic risk, there are additional obligations that are going to apply, such as model testing, such as providing information of any incidents that might occur in the lifetime of this technology working to the relevant regulators, among others. So this is a general overview of how the AI Act is governing general purpose AI systems. But of course, the AI Act does not exhaust all kinds of issues, the regulation of all kinds of issues that could be coming up through those systems. For instance, issues regarding content moderation might be regulated through other instruments such as the Digital Services Act. But giving you an answer, Marie, yes, there are several rules on general purpose AI systems under the EU AI Act.
Well, that question certainly generated a very interesting analysis. I got a question also from you, Pedro, and he comes from your native Brazil.
Yes.
And he was wondering about the consumer position. I mean, can consumers that are directly affected by the AI systems do anything under this AI Act? Are there rights that they have to start legal proceedings under the AI Act against the responsible companies, for example?
Yeah. So under the EU AI Act, the rights that users or consumers have are very limited. So basically what persons affected by those AI technologies can do under the EU AI Act is the following. They either can have a right to complain to the Market Surveillance Authority about what is happening or about their inaction, and request them to take action and to somehow pursue the companies and to charge them with fines or other punishments that are established under the EU AI Act. They also have a right for an explanation, for transparency, for clarifications regarding how outputs were made when AI systems were used to create predictions, recommendations, or decisions that somehow affect them. But the AI Act in itself does not create any additional right for consumers to ask for compensation. If consumers want to ask for compensation, they will have to pursue other means. So this is a complex matter. To a certain extent, this is partially harmonized in the EU through the Product Liability Directive. So this directive establishes that whenever a product is defective, there are certain procedures that can be pursued for us to try to redress the consumer, to try to give him compensation for that. And the Product Liability Directive has been recently updated, clarifying that software is a type of product that is covered there. So some types of defects related to product would apply to AI systems. So whenever AI systems somehow create harms related to data loss or some violation of property, for instance, this is a kind of claim that we could pursue under the Product Liability Directive. But there are many kinds of other types of claims involving intangible issues that would not fall under the Product Liability Directive. We are talking about violations of fundamental rights, of personality rights, cases of discrimination. So for these types of claims, each individual user or consumer in the European Union would have to go to their national legal system and see what are the probably tort law rules that apply there, and pursue those to ask for compensation. There is no harmonization regarding that particular topic in the European Union. There was a project for an AI Liability Act that was withdrawn last February. So since that happened, we don't have rules that fully harmonize this issue in the European Union.
And this act is relatively new, and I think like all legal developments, it takes time and acting it out and exploring before really these kind of issues of consumer rights are meted out, if you want.
Yeah, and it's possible that we still are going to have some new instrument that will still try to harmonize liability issues in the European Union. Still unclear whether, but even though it's still early, it's a crucial aspect. Unless we have a lot of clarity about how users, consumers can be compensated, we can question whether this is truly an effective system.
Very good. I'd like to move on to a question from Amadou from Niger, and he comes back to actually the initial subject of this masterclass, and basically he puts you on the spot, Pablo. Do you think the AI Act could deter innovation or not?
Well, this is, we can get now in the end to say this is an extremely difficult question and that has even more nuances than it seemed at first. So many things to say here. First of all, we have to have in mind that we don't have full clarity yet about what will be in detail the obligations of the AI Act. As I have told you before, we have general obligations, transparency, non-discrimination, accuracy, but how those will translate in practice still to be determined, to a great extent, will be determined on technical standards that are still being produced today. So we don't really know exactly how stringent are the obligations under the AI Act. This is still being defined. But in any case, we of course have to keep an eye on how those standards are being produced and make sure that they find a balance between protecting the rights of consumers and not deterring innovation. But as I have explained with this risk-based approach, the intent of the AI Act was in itself to create a balance between those different values through this risk-based approach. But what I wanted to raise is an important paper by famous scholar Anu Bradford on this tension between regulation and innovation, where she has a very important position that I think I'm very much closely aligned to what she thinks. She says that what is making Europe fall behind in terms of innovation is not necessarily those regulations revolving around technology, around AI systems. There are more infrastructural matters that we have to look at.
For example?
For instance, our ability to attract international talent in the field of technology as opposed to the United States. Can we be as competitive as them in attracting the best scientists, the best specialists? Insolvency laws. We have insolvency laws that are extremely hard on the companies, and that contrarily to the United States, where there's much more flexibility about being able to try to reconstruct your business, even though it has been insolvent, creates somehow a deterrent for businesses to move on. Another question also involves capital markets. There's not sufficient financing available, venture capital. There are several legal issues that are not harmonized in the European Union. There's lots of regulations and directives, but many questions are still regulated in a different way if you go to different EU member states. So this fragmentation in terms of legal systems and applicable rules still in many questions might be a structural matter deterring innovation much more than a regulation that is not yet even in place.
That insolvency issue, I mean, basically bankruptcy is okay in the US. There's a culture where you can bounce back and learn from your mistakes, which in Europe is still, I think, a counterculture or harder to take risks and so on because of that fear of insolvency and going bankrupt.
A very different mentality, and something that is crucial for innovative companies. Most startups, they are going to fail, they are going to go insolvent, and based on that learning, something new will come up. So you have to create a flexible framework that allows them to reconstruct, to rebuild the business, and not so much to punish them for something that in an innovative environment is very much likely to happen in many cases.
I think there's time just for one final question, and that's from you, Françoise. And you were wondering about the acts, the AI acts, penalties for non-compliance, and are they sufficient to ensure responsible AI development, particularly for these big tech companies? Good question, Françoise.
Yeah, this is a very important question. I'm not sure that I have a clear final answer. I mean, the EU AI Act has established for certain types of violation a significant amount of fines. So I think for violations of prohibitions or putting into the market banned AI systems, it can go up to 7% of the turnover of a company over a year. Even for those big tech companies, that can be a significant amount. But of course, we know that in some instances, even though those fines might be significant, large companies of technology might choose to implement those technologies in the market, knowing that their profitability still is going to be higher than any kind of fines that might be imposed upon them. So then we have to think about alternative ways to try to make them become compliant. So, for instance, it's not only about a financial impact, but also reputational impact. Is there some way we can publicize more clearly about those violations, about the fact that they are not acting according to the law? And besides the EU AI Act, there could be also fines under other legislative instruments, under the GDPR, or through any other forms of regulatory authorities' actions. So this is a very relevant question, and as the AI Act is implemented and enforced, we might have to make some adjustments to make sure those companies align to the law.
Well, both the masterclass and this question and answer exchange, I'm sure, has provoked a lot of questions from you viewers of this final Reskill session in this academic year. My thanks to you, Pablo Baquero, for a very rich and important exchange on the EU AI Act. And I'd like to say that if you do have more questions, please do send them in. Pablo will be happy to answer them and give more of the, I think, complexities of this issue, which I'm sure we'll be hearing much more from. Until the next academic year, then, it's our thanks from the Reskill team, and see you soon.
Creativity is a social experience. You're not creative alone.
Despite its struggles, ESG can overcome the criticism and help make companies more accountable towards all stakeholders.
Today we're going to talk about things like trust and teams,
Bitcoin, blockchain, cryptocurrencies,